Good morning. This is Steve Eckhouse. I'm here with Kristen Michael and Evan Belosa of McDermott, Will & Emery. The subject is Understanding Equal Pay Laws and Avoiding and Defending Pay Equity Claims. On this day 50 years ago, President John F. Kennedy signed the Equal Pay Act, guaranteeing that women earn the same pay as men for work of equal value. Last week, during the inauguration and during the Women's March, we heard a lot about equal pay. I think just to put us into context, a couple of statistics are relevant. By most estimates, women are paid only 70 cents for every dollar a man makes. There's one exception. Women with college degrees who are single and childless make 8 cents more an hour than their male counterparts. That's largely because more women are going to college than men. But to put this in other contexts as well, men and women who both have college degrees, men have a 6% increase in compensation in their first year than women have. So we're dealing with a fairly significant endemic problem. The Equal Pay Act requires that an employer provide equal pay to men and women who perform equal work, unless the pay difference is based on a factor other than sex. Frequently, EPA claims, Equal Pay Act claims, are brought together with claims for sex discrimination and compensation. Again, to put it in context, for the past 20 years, the EEOC, Equal Employment Opportunity Commission, has received on average 1,100 Equal Pay Act charges per year, about 1.1% of all charges received by the EEOC. Plaintiffs seeking to prove an Equal Pay Act violation must show that, 1, employees of the opposite sex in the same place of business are paid different wages. 2, the employees perform equal work in jobs that require equal skill, effort, and responsibility, and the jobs are carried out under similar working conditions. If plaintiff makes this showing, what we call a prima facie case, the employer has the opportunity to assert one of 4 statutorily recognized affirmative defenses. These are defenses that the employer has the burden of proof to show, at least initially. Must show the wage discrepancy is justified if it's based on a seniority system, a merit system, a system that measures earnings by quantity or quality of production, or differential based on a factor other than sex. The employer produces evidence of affirmative defense. Burden shifts back to the plaintiff to show the profit reason as a pretext for sex discrimination. Now, there's a case which is sort of instructive on what it means to prove a prima facie case. EEOC versus Port Authority in New York and New Jersey, 768 F. 3rd 247, Second Circuit case of 2014. Female attorney filed a discrimination complaint with the EEOC. EEOC then brought an action that the Port Authority paid female and male supervisory attorneys unequal wages for equal work in violation of the EPA. Further asserted the attorneys were similarly situated because they shared the same job code. The district court required the EEOC respond to discovery requests from the Port Authority, clarifying its position that the attorneys performed equal work. The EEOC provided only generalized conclusions applicable to all practicing attorneys, such as they have the same professional degree, they work under time pressure and deadlines, and utilize analytical and legal skills. The district court dismissed the complaint, finding that the EEOC complaint merely tracked the language of the statute, and that the discovery response, interrogatory, by failing to allege facts with particularity, failed to allege the attorney's jobs required equal skill and effort. The Second Circuit affirmed, holding that, quote, a discrimination complaint must at a minimum assert non-conclusory factual matters sufficient to nudge its claims across the line from conceivable to plausible to proceed. Kristen, you want to pick it up?
Good morning, everyone. Thank you for joining us here for the next hour to discuss this issue of pay equity, which really was one of the most important employment law issues in 2016. And as many of you may know, you may have seen in the media, it's an issue that's been a big focus of a lot of companies and a lot of CEOs. A number of them have come out in the past year saying that they are going to have a real focus on this issue, and many of them have said that they have already started to do those types of inquiries and assessments, and in certain cases have discovered that, although inadvertent, that they themselves have had issues of pay disparity in the workplace and are taking steps to rectify that. We'll talk about what 2017 is going to look like as we go through this discussion, but I think it's fair to say that the focus on this issue is not going to lessen. Steve referenced some of the recent developments with the Women's March that took place over the last weekend, and certainly there are members of the current and new administration that have expressed some support for this issue of pay equity. And of course, my colleague Evan is going to go through today a number of the changes in state laws. But all of these things together suggest that the issue is going to be increasingly an important one for employers as we move forward. So what we really wanted to do today was to just do an overview of all of the rights and obligations and the sources of those rights and obligations for employers on this issue. And to that end, we wanted to touch on the Equal Pay Act, the federal law that is kind of the governing law on all of these issues. We also wanted to talk about pay equity issues under Title VII, which also touches on the issue, and then touch on the state law changes that have occurred most recently, and talk about some of the other requirements that have been issued in the last year, most notably the EEO pay data rule that employers will need to start complying with beginning in 2017. So to that end, I want to jump right in, and I want to start with the Equal Pay Act. And, you know, I've discovered in my practice that the Equal Pay Act for many employers seems to be more simple on its face than it really is to carry out in practice. So I want to go through the Act, and I want to kind of break it down into its component parts and talk about how all of this works, because I know that it's been a fruitful discussions with clients that I've had over the last few years. So if you look on slide 3 of the webinar presentation, you'll see that the Equal Pay Act states that employers may not pay unequal wages to men and women under 3 different circumstances: when they perform jobs that are, number 1, substantially equal in skill, effort, and responsibility; 2, when that work is performed under similar working conditions; and 3, when the work is performed within the same establishment. So I want to unpack each of those 3 components to talk about them. The first piece, which is substantially equal skill, effort, and responsibility, the first thing to note there is that the work does not have to be identical under the Federal Equal Pay Act in order to require or potentially require equal wages. But it does have to be substantially equal in skill, effort, and responsibility. So it's not an either-or situation. The work will have to be equal with regard to all 3 of those pieces: skill, effort, and responsibility. So what is equal skill? Skill is measured under the Equal Pay Act by things such as experience, ability, training, and education. What's probably the most elusive for many employers about that piece of the statute is that the requirement that there be equal skill needs to relate to a job requirement. So in other words, one thing we often hear is that sometimes when we're doing a pay audit or we're monitoring potential pay disparities, we'll have an employer say something like, well, you know, John is making more than Mary because John has a master's degree and Mary has a bachelor's degree. But the next question needs to be, is the master's degree required for the job? Because if it's not required for the job, then it's not a factor that can be relied on to justify a pay disparity. So the important thing to know about the skill factor is that those factors do in fact have to relate, and an employer would have to be able to show that they are relate to and are required for the particular job. With regard to this piece of effort, what does effort mean? Effort under the Act is essentially the amount of physical or mental exertion that is required for the job. So to give an example with regard to effort, if you have employees who are performing assembly line work, and all employees are doing the same work with regard to producing a widget, but there is an individual at the end of the assembly line who has the added responsibility of packing the widgets after they come down the line, then that is a difference in effort. Assuming the effort that's employed is not so minuscule, a difference in effort can also justify a disparity in wages. With regard to responsibility, the factors that are looked at to determine whether responsibility is equal are things such as whether the individuals work without any supervisory authority or any supervisory oversight. It's another factor that's reviewed is whether or not the individuals themselves employ supervisory responsibility. And third, there's an inquiry into whether or not the responsibilities or the job functions of the individuals, to what extent that they are meaningful and important to the employer. So that's the inquiry that will be used to determine whether individuals are working in jobs that are substantially equal in skill, effort, and responsibility. All right, so the second prong is the jobs must be performed under similar working conditions. That, for the most part, is probably the easiest factor to understand. It essentially goes to, is there a similar type of physical surroundings, and or does either job have any particular hazards involved in it that the other job does not have? The third prong is within the same establishment, and that generally means, at least for purposes of the Equal Pay Act, Evan's going to discuss that it's not necessarily true under some state laws, but it does mean that generally the jobs that will be compared will be jobs that are within the same physical location. There are some exceptions to that. For example, if there is a certain administrative unit that hires employees and sets their wages, notwithstanding the fact that those individuals may work in different physical locations, either the EEOC or a court may compare those jobs, even though they are located in different places. And with the increasing use of telecommuting, more and more we are seeing the EEOC or the courts say we also may compare jobs that are being performed in different locations based on the fact that there's a lot of telecommuting that's used within an organization or within a company. Okay, so if there appears to be two individuals who are performing equal work under all of these three factors, are there any defenses an employer has if those individuals are being paid a difference in compensation? And the answer is yes. You can see on your screen that there are 4 exceptions under the Equal Pay Act. And again, this is an area where I find that there's a lot of misunderstanding or a fair amount of misconception. So the 4 exceptions, as you can see, are there can be a disparity based on a seniority system, there can be a disparity based on a merit system, a system that measures earnings by quantity or quality, or a difference in pay can be based on a differential that is something other than sex or gender. Here, where I see misconception is oftentimes when we're doing an analysis of pay differences among jobs, I will hear a company say, well, so-and-so is paid more than his comparator because he has more seniority within the company. And that may or may not actually work as a defense. And here's why. If you look on your next slide, on slide 4, you will see that the seniority system or the merit system or the incentive system that's going to be used has to be a bona fide system, and it has to meet certain criteria. So it has to, for example, be an established system. It can't be something that's ad hoc, that's used to justify wage differences after the fact, or it cannot be a system that has not had established criteria that's been communicated to employees. So in the case of a merit system, for example, what you would want to have is the use of maybe performance evaluations, where you lay out the criteria as to how each individual within a certain job or classification is going to be evaluated, and then explain those evaluation factors. Not only do you have to have an established system, but you also have to apply the system and the criteria consistently and even-handedly. If that's not done, then an employer potentially loses the defense of his or her seniority or merit system. And then finally, if the defense is based on one of these systems, the employer is going to have to show that that system accounts for the entire difference in the pay disparity, which can often be a little elusive at times. Okay. The final defense, and a defense that is probably most often relied on by employers, is the factor other than sex defense. And like the seniority or merit system, it has to be a factor that, one, both the employer and the employee understood was going to be a factor that would be applied in setting compensation. So in other words, this is not a defense that can be used after the fact to explain a wage differential. Like the bona fide systems with regard to seniority and merit, it also has to be applied consistently, and it must correspond in total to the pay differential. And finally, as we talked about above when we talked about differences based on skill and experience and ability, it has to be related to the job. So simply saying that, well, we relied on this factor that has nothing to do with gender or sex, but that factor has nothing to do with a job requirement, the employer hasn't established the most necessary requirement to use the factor other than sex defense. The Equal Pay Act, unlike Title VII, which we're going to talk about in a minute, is an act that addresses disparity in pay based on gender. Title VII is broader, and we're going to talk about that in a minute, but this only deals with pay disparities between men and women. But it goes both ways. Certainly a male could also have a pay equity claim just as much as a female could. A couple important things to note about the Equal Pay Act. Generally, it's a 2-year statute of limitations. If an individual can show that the employer willfully intended to have unequal pay, then there can be a 3-year statute of limitations. I think it's important to note, too, with regard to the Equal Pay Act, and this is a difference in relation to Title VII, is that there does not need to be any intent to discriminate. And that's obviously a big difference between Title VII and often why employees may bring causes of action under both statutes. But there need not be any intent whatsoever. It just the ultimate effect has to be that there is a pay disparity and there's no defense to explain it. Unlike a Title VII claim of pay disparity, an individual can either file a charge with the EEOC or they can go straight to court to file their claim. They need not go through that administrative process. And as we just previously discussed, again, somewhat unlike the way a Title VII charge is processed, an employer ultimately bears the burden to prove that there's a good reason or a defense for the wage disparity. Okay, so just a couple of important things to know about the EPA that are the types of questions that I most often get, so I thought would be the most important ones to flag. Equal wages have to be paid in the same form. So in other words, an employer cannot pay a higher hourly wage to a male and then attempt to make up the difference with the female by paying a bonus or some other form of compensation. And that works both ways, obviously. As I just mentioned, possession of a skill not needed to meet the requirements of the job can't be considered. And again, this is just something that often crops up in our discussions with companies as they look at these issues. Job content, not job titles, determines whether jobs are substantially equal. So one thing that we sometimes see that is kind of a mistaken way to approach this is to just compare compensation, salary, wages within job titles. And that's not the relevant comparison and wouldn't be for purposes of any EEOC type of audit or any court action. Oftentimes, jobs are compared that contain completely different titles and even cross departments. So it's important to really look at what people are doing as opposed to what their title is. And then finally, often something that's missed and many individuals don't know about is that if there is inequality that's discovered and a company wants to address that and rectify that, employers cannot reduce the wages of either sex to equalize the pay. There would have to be a pay increase. All right, so Title VII, I want to touch on that briefly and then hand it over to Evan to talk about state laws. Title VII is different because in order to show discriminatory treatment, so in a discriminatory treatment Title VII case, an employee must show that he or she is paid less because of his or her sex or because of another protected status. So an individual may have a claim that he or she is paid less because of race or nationality. Obviously, under the ADEA, a similar type claim could be brought based on age, or under the ADA, a claim could be brought that an individual was paid less because of a disability. As I mentioned, the burden of proof is a little bit different in Title VII case. Once the employee establishes what we call a prima facie case, that he or she is in a protected group, that they are paid differently than similarly situated employees, after the employer explains or gives a reason for the disparity, the employee then has to prove that that reason is not a valid reason. It is a pretext. Unlike the Equal Pay Act, there are no liquidated damages under Title VII. However, there are the potential to recover punitive damages or emotional distress damages, although subject to caps. Under the Equal Pay Act, I may not have mentioned that it does provide for double damages. So that is a feature, and again, another reason why oftentimes Title VII and Equal Pay Act claims are coupled with each other. Title VII is a little bit of an easier cause of action in that the claimant does not need to show that jobs are substantially equal to that of someone making a higher salary or a higher rate of pay. And there's no requirement that work be within the same establishment. The thing I think to watch with regard to Title VII is this issue of disparate impact. Because unlike disparate treatment cases under Title VII, there does not need to be intent shown. In other words, there does not need to be it does not need to be shown that there is an intent to discriminate against individuals because of a protected status. And one thing that I thought was really interesting that I saw on the Department of Labor's website and in one of their publications recently is that they seem to be having an increased focus on disparate impact pay equity cases. And notably, they mentioned that where salaries and bonuses are negotiated, that there has to be a real focus that those negotiations and the resulting pay doesn't result in a disparate impact on women or individuals in another protected category. So to me, that may be a signal that the EEOC may be approaching some of these cases going forward on more of a disparate impact basis. Okay. I'm going to hand it over to Evan, and Evan's going to talk about some of the more recent developments under the law with regard to pay equity.
Thank you, Kristen. Thank you, Steve. Good morning, good afternoon, depending on where you are. So we're going to talk about state law largely, but before we get there, let's talk about some of the recent developments at the federal level. When we talk about recent with regard to legislation, we need to go back to 2009, in large part thanks to endemic gridlock. But in 2009, the Lilly-Ledbetter Act was passed almost 8 years ago to this day, the first legislation signed by the newly elected Barack Obama. The act derived from a Supreme Court case in 2007, which dealt with the statute of limitations under Title VII. Claimants had made the argument that on each paycheck, which was essentially infected by disparate pay equity, a new violation occurred. The defense said essentially an original sin position that if there was an unlawful employment practice, it had occurred at the beginning of setting her pay and therefore was well outside the statute of limitations. 5-4 decision, the Supreme Court agreed with the defense position. Justice Ginsburg's dissent essentially all but asked Congress to act and correct this, and Congress did with the Lilly-Ledbetter Act. The act stated the EEOC's long-standing position that each paycheck that contains discriminatory compensation is a separate violation regardless of when the discrimination began, and that has been law now for 8 years. So we haven't seen much in the way of legislation. There have been some legislative acts proposed in Congress. The Paycheck Fairness Act has been languishing since it was introduced by then-Senator Hillary Clinton in 2005. The Fair Pay Act, again, neither of these have come up for a vote. So we look at the executive agencies, though, which have been more active in the more recent past. So pay transparency for federal contractors was introduced in January 2016. At the same time, the EEOC and DOL proposed a joint regulation to modify the EEO1 report, commonly known as the Employer Information Report. The EEOC collects workforce data from all employers with 100 or more employees through that report, traditionally collects data about gender and race and ethnicity of employees by job groupings, but then announced in early 2016 that it would require employers to report on the W-2 earnings and hours worked for all employees by race, ethnicity, and gender. This is a big deal. This covers 60,000 employers and 63 million employees. After some pushback, the compensation date for compliance was pushed back to March of 2018, which seems kind of far off, but you can't really ignore it because it will apply to 2017 compensation data. So what is the EEOC actually doing here? Well, what they're going to do is, in addition to reporting the number of employees by gender, race, and ethnicity, employers are now required to provide employee compensation information and the number of hours worked by employees over 12 different pay bands. Note, this isn't a requirement to report individual pay or salaries, but it is an aggregate of substantial amount of data. The EEOC's goal here is to identify businesses that may have pay gaps and target those employers who are discriminating on the account of gender through enforcement actions. They plan to publish reports using aggregated data, train investigators to use analytic software tools to identify potential indicators of discrimination, and warrant additional investigation. As you might imagine, there was significant pushback from the employers regarding both the efficacy and the potential costs of compliance. The government estimated 6.6 hours of compliance time, which seems ludicrously low. The Chamber of Commerce, in opposing the original, estimated about 500 hours for compliance, which may seem a little high, but is probably closer to the ballpark of compliance. So the data is going to be based on the workforce snapshot period of any pay period between in 2017. Employers have the discretion to select pay periods during a 3-month snapshot window. So again, this is information that you're going to have to start thinking about in the near future, if not already. Now, I think the obvious question that's going to pop up from a lot of folks is, this is a 2016 EEOC action. Do I care anymore? Is this something I'm going to need to comply with based on the new administration? And while obviously things are somewhat in flux, equal pay has been a more bipartisan issue than some might imagine. We're going to talk about the states soon. 2 of the 4 states that amended Equal Pay Act to make it more make it easier for plaintiffs to file had Republican governors who signed those acts. Many believers think the EEOC rule will survive based on what some have called the Ivanka factor. Again, no one is quite sure. We can't say with perfect certitude, but if I were to be advising anyone, I would say that the EEO-1 information is probably something you do need to comply with, and I doubt it's going to be repealed anytime soon.
And Evan, let me just jump in for a second, because I think in addition to the fact that this is just a huge administrative requirement, and I'll go so far as to say burden on employers to put together this data, I think the other thing to just keep an eye on is as any of you who've had the unfortunate circumstance of being involved in EEOC charges, one of the first things that the EEOC asks for is, when they ask for documents, is a copy of the company's EEO-1 report. And so you're going to be handing over this information that contains all of this wage data, and there's nothing that prevents the EEOC, as many of you may know as well, from looking at that EEO-1 report and launching an investigation into an issue of pay equity, regardless of the fact that an individual filed a charge over that or not. So it's potentially a lot of ammunition for the EEOC, and it really underscores the importance of looking at pay disparity issues in the workplace sooner rather than later.
Yeah, thank you, Kristen. The other thing that employers have also pushed back on is data security. As I said, this covered 63 million employees. Employers have expressed concern that you're aggregating an awful lot of information about individuals that they may not want out in the workplace or want out in the public domain, and handing it out to the EEOC, which could be subject to a cyber attack. Obviously, something that has proved somewhat prescient in the recent times. So let's talk about state law now. So state law has become the most fertile area of development here, and if you have workforces in any of 48 states, everything but Alabama or Mississippi, you have a state Equal Pay Act of some kind on the books. Obviously, employees in those states are still covered by federal law. So we saw significant progress in 2016 in amending state law. 4 states had laws either signed or which came into effect, which modified earlier laws and broadened the standards state equal pay claims. And we're going to talk about all 4 of those. They're California, New York, Massachusetts, and Maryland. So before we even get in, the question is, why is state law important? Why do the states engage in certain actions here to broaden the standards here? I think it's largely based on that the standard in the EPA, as Kristen went into, was developed based on prevailing pay practices in the early 1960s. American industry at the time was, far more heavy industry centered. They used formal, systematic job evaluation plans to establish wage structures. What was equal work at the time was a lot easier to assess than it may be now, as America has transitioned more to a service economy in which significant women have entered the workforce as they were not in 1963 in a managerial and executive position. So amending the EPA to cover not just equal work, but substantially similar work or work of a comparable character may solve a wage glass ceiling issue for supervisory or executive women, but that's not going to happen, at least anytime soon. So since we're not there at a federal level, the states have taken the actions to address some of the wage disparities, and with a large focus on service-level executives. It may surprise to know that as we break down that 79% number, Some of the biggest disparities are in the service and executive industries. The highest is financial planners. Women earn 58% of men in the financial planning space. We don't do a whole lot better here in the law world, 77%. So the states have taken the lead on this. The California Fair Pay Act is the first one we're going to talk about. And again, if you have a California-based workforce, you're going to need to comply with this. There are essentially four major revisions in the statute that you need to be aware of. The first is under the umbrella of what I call pay equity. It's three major changes there. The replacement of the equal work standard of the EPA with a substantially similar standard. Employees can be compared now even if they don't hold the same or substantially equal jobs as they would need to be under the EPA. The new law requires only a showing that the employees are engaged in substantially similar work when viewed as a composite of skill, effort, and responsibility, and performed under similar rather than equal working conditions. What is skill? Skill is, as it has been, experience, ability, education, and training. We've talked about effort, responsibility, working conditions. Those will remain similar to the EPA. But the purpose here is to allow for comparisons between employees who perform similar tasks regardless of the job title. The equal work standard, obviously, is far more difficult, and as plaintiffs have found in many, many EPA cases, it's a significant burden to get over, to say that we are equal or substantially equal. California's idea here is to loosen up that standard. So now wage differentials are prohibited for opposite-sex employees doing substantially similar work. That's the first major change in pay equity. The second would be the deletion of the same establishment requirements. Previously, employees would have to be compared in the same establishment, so the same factory, the same workforce. By deleting this without replacing it with anything else, as the other states have, as we'll see, employees can now be compared even if they don't work at the same establishment. This means the pay of an employee can be compared to the pay of other employees who work hundreds of miles apart. And note, I think it's interesting that nothing in the Act limits comparisons with other states. So for multinational, multi-state entities, it's possible that a plaintiff can make an argument that a comparison should be made from California to a state with a standard of living structure vastly different. We don't know how the courts will interpret that yet, but it is possible. The third is the new rules for justifying pay, limiting the factors the employees can use in the defense. The factors, again, will remain similar to what the EPA provides, so the seniority system, the merit system, the system that measures earnings by quantity or quality of production. And it's the last, though, the bona fide factor other than sex that is critical to understand. That's often where employers are going to defend these actions. And, in some places it's been looked at as a catch-all, but California is trying to push back on that. It still requires a bona fide factor other than sex. It would still require skills, education, training, experience. That's consistent with the existing law, but the new law requires that the employers show, first, that they're not based or derived from gender, second, are job-related, and third, consistent with business necessity. Business necessity is defined now as an overriding legitimate purpose such that the factor relied upon effectively fulfills the business purpose it is supposed to serve. Even that bona fide factor will not apply if the employee can demonstrate that an alternate business practice exists that would serve the same purpose without reducing the wage differential. Okay, so that's a lot of verbiage. What does it mean? I think it's a few points that are important. First, this is going to be even more fact-intensive than it was before. Bona fide factors appear to be specifically crafted for each position in question. What is an overriding legitimate business purpose such that they're consistent with business necessity? How do we know if an alternate business practice exists? An employee is going to suggest, and presumably a court will decide, if a business should have applied an alternate business practice. This is going to take an awful lot of litigation to hammer down what this means in real life. What does applying the factors reasonably mean? Obviously, we've seen reasonability standards in the law before, but not in the EPA claim in the states. Note that the amendment is silent on retroactivity, so the expectation in this is this going to be purely prospective, but again, silence obviously leads to questions. And finally, with regard to pay equity, one of the big questions that folks have asked in light of this, is can we still even negotiate salaries? So salary negotiation is not prohibited. Of course, it's a vital part of employing somebody, but you've got to be careful that pay differences need to be based on a specific bona fide reason that you can justify in light of the permitted reasons here. So that's going to heighten the standard for when you negotiate and hire somebody. Okay, so that's pay equity in California. Pay transparency. Employers may not prohibit employees from disclosing or discussing their own wages or the wages of others, or from aiding or encouraging anyone to do so. Note that nothing can require an employee to disclose their pay, and there is an exception built in for employees whose jobs it is to know pay. So the HR director can't just put up a list in the cafeteria with everyone's pay. Why are we doing this? The expectation is that siloed silence keeps wages down. Note the overlap with the NLRA, Section 7. Some folks would say, look, employees can already discuss pay, so why do we need this? The law extends protection to some who may not be considered employees under the NLRA, such as supervisors and managerial employees. And note that even employees, around 50% of employees would report that they are unaware that they are prohibited or discouraged from discussing compensation, or report that they are prohibited or discussing compensation regardless of law. So I think this is an important idea to try to make sure that there is sunshine here. The third is records retention, just extending from 2 years to 3 years, the requirement to keep wages, pay rates, job classification information. And the last is enforcement, an additional private right of enforcement for retaliation for any conduct permitted by the statute. Otherwise, the damages enforcement are going to remain as is. So what does it all mean? Claimants are going to actively start testing what the difference is between substantially similar and equal, what categories qualify as bona fide factors other than sex under the heightened standard that California now provides. 2 more laws passed in California more recently. The Wage Equality Act extends these provisions to ethnicity and race. And another law will prohibit employers from using prior salary as the sole basis to justify pay disparity. Note that Governor Brown vetoed a similar bill in 2015, which would have prohibited even asking about salary history. So that's California. Massachusetts, let's talk about that next. Massachusetts law doesn't take effect until July of 2018, so we have a little bit of time. It was prompted by a lawsuit by female cafeteria workers alleging they did comparable work to the male custodians but were paid half as much. And the court ruled that the state's law did not set a standard for comparable work, and that triggered the lawmakers into action. So the first thing they did is redefine comparable work similar to California, substantially similar skill, effort, responsibility, and performed under similar working conditions. I think the big thing to notice in Massachusetts, without duplicating what we've already talked about, is the defenses. Unlike in California and the federal EPA, there's no catch-all. There's no bona fide factor other than sex affirmative defense available. So the affirmative defenses are a little bit broader, seniority system, merit system, and the system that measures earnings, but they also have added geographic location in which the job is performed, the education, training, or experience to the extent reasonably related to the job, and travel, if travel is a necessary condition. So note that although Massachusetts, unlike California, still retains the geographic location in the standard, it flips it to the affirmative defense. Here's what's interesting about Massachusetts. Massachusetts is the first in the nation to create a separate affirmative defense for employers. If an employer has completed a self-evaluation of its pay practice that is reasonable in detail and scope in light of the size of the employer within 3 years before an action is commenced and made reasonable progress toward eliminating the pay differential uncovered, that will suffice as an affirmative defense to a claim. So note that the reasonableness is defined in light of the employer's size, that progress is defined as eliminating the pay differential, not the unlawful pay differential, and note that the Attorney General will post a standard template for what the affirmative defense pay practice review will look like, but hadn't done so yet. So that will make it a little easier for employers and is obviously meant to incentivize them to take a look at self-evaluation. Massachusetts law did one other thing that is unique in the nation, is the first in the nation to forbid employers from inquiring about wage or salary history before making an offer of employment that includes compensation. You can't get around it by asking a former employer or prospective employer to give such information. You can't ask your recruiters to get that information. If the employee volunteers it, you can confirm it. But this is obviously a substantial change. It's going to require a lot of paperwork in the sense of training, modifying your applications. The intent is to target the start low, stay low phenomenon, which if you come in low, salary being so sticky, you'll have that problem that repeats, and which was the case in the Lilly Ledbetter case. Private right of action within a 3-year statute of limitation for each time an employee is paid, again consistent with Lilly Ledbetter. So that's 2 of the states. Third state that we'll talk about is Maryland. This is in effect October 1 of 16, so in effect now. And again, without duplicating some of the concepts we've talked about already, biggest difference from Maryland, this is very interesting, is that it reaches beyond gender. It's the first in the nation to prohibit discrimination on the basis of sex or gender identity, such that gender identity is added to a protected class. This is obviously going to create not only litigation, but a little bit of uncertainty. Nothing in the law indicates how employers are supposed to factor in gender identity when it's not apparent on its face, and that will no doubt be tested. The law doesn't establish when an employer must know or should have known of a gender identity. The other thing that's very interesting about Maryland is it reaches beyond pay. It prohibits employers from providing less favorable employment opportunities, which includes placing employees into less favorable career tracks, failing to provide information about promotions or advancements, or limiting or depriving employees of employment opportunities because of sex or gender identity. Now, career track isn't defined here, but we can probably assume it's targeted at what's been so-called the mommy track. And it's going to be interesting to see how the law develops, because this is, again, the first in the nation to include such concepts in its state law. Like California and Massachusetts, Maryland modified the equal work standard to work of a comparable character. Again, this is a new formulation. We'll need to test how it's determined. It splits the difference on location. California, as we discussed, permits any location, and Massachusetts requires the same location but kicks it to the affirmative defense. Maryland will say that it applies to all workplaces in the same county. So it's no longer the same specific location, but you've got a comparator across the county. Again, as with the other states, we've limited the other than sex affirmative defense, and again, consistent with how the other states have done it. It must not be based on or derived from gender-based differentials, must be job-related, and must account for the entire wage differential. Again, as we've also seen, you can't forbid employees from inquiring about, discussing, or disclosing their wages or the wages of another employees. Again, exceptions for folks like HR who have reasons to know. The employers can establish reasonable limits on time, place, and manner. Again, that's consistent with the other states as well, provided they're in a written policy to the employees. And again, there are anti-retaliation provisions within Maryland's law. Maryland also created an equal pay commission, which is going to evaluate wage disparities, establish a mechanism to collect data, recommend best practices, and develop partnerships with the private sector to identify methods of raising awareness and methods of data collection. So Maryland has put a lot of muscle into its Equal Work Act. The fourth and final state that made a significant change in 16 was New York. New York changed, I think, a little less than the other 3 states. It did not change the equal work and equal skill standard, so it reaches a little less than that of California, Massachusetts, and Maryland. The bona fide factor other than sex has been amended, and again, as we saw, New York also uses a business necessity bona fide factor standard. Business necessity defined a little different in New York as a factor that bears a manifest relationship to the employment in question. And again, as we've seen, the employee can demonstrate that an alternative practice exists, which would serve the same purpose, and the employer has refused to adopt the practice, then the bona fide factor drops out to be used as an affirmative defense. Again, what will be business necessity is your guess is as good as ours, but we'll certainly start to see litigation that's going to answer this question. Employers may not prohibit employees from sharing wage information. Again, as with Maryland, reasonable time, place, and manner discussions. And the geographic area, similar to what Maryland. I'm sorry, I think I dropped off for a second there. What I was saying with New York, the damages are the big substantial difference here. Damages have gone up from 100% of the total amount to 300% for a willful violation, so that's pretty substantial. That's pretty much it for the state. Nebraska made a small change in its law to change from 15 employees to 2. But other than that, those are the states that have achieved significant changes. We put together a very helpful chart, I think, that kind of shows the difference between the 4 states that have changed recently, the federal laws, with regard to some of the key things: who's protected, who's the comparison group, location, proof, and the remediation required.
Yeah, Evan, and let me just jump in briefly to let everyone listening know that local cities, also local areas, we need to keep our eye on them as well, just like we've seen in the paid sick leave arena, where in addition to state paid sick leave laws, many cities and townships have begun or have already passed paid sick leave laws. We're starting to see some action at the local level as well. So just recently, Philadelphia passed at the city council level and is now sitting on the mayor's desk some amendments to their local laws, which also prohibit employers from having a rule which prohibits employees from discussing or comparing wages or compensation data. So I think it's another thing that we're going to be seeing, or another area where we're going to be seeing more pay equity rules and legislation coming from.
Yeah, and New York City introduced a bill as well in a similar vein to Philadelphia, is prohibiting, looking at earlier pay information in an attempt to do what some of the state laws have done here. So I thought it'd be helpful just to highlight a recent arbitration that I read about that I thought was helpful in detailing how this change in state law may be useful. A female chief technology officer at a technology company claims that she earned substantially less than the men on the executive team. Her annual increases were smaller, her bonuses were smaller, her stock option grants were smaller. The company was a tech company, and she was leading the tech function. She arguably could have made more than her male executive peers. The company conceded her performance was excellent. She ran the largest department that was critical to the business. She brought federal and Maryland Act claims. The arbitrator ruled against her on the federal claim, saying that the substantially equal standard was not fulfilled here. The skills and responsibilities for different departments was different enough that she failed on the EPA claim, but the arbitrator ruled in her favor on the Maryland work of comparable character standard. So I think that's just a highlight of how state law may impact both defending and bringing these cases. We can talk about a few recent cases, and I know we're running short on time, so I'll be very brief on this. Law firms are in the target zone right now. They make juicy targets. 3 major law firms received complaints in 2016. All similar cases. A female partner brought an action, some cases asking for class action, alleging that she did not make equity partner despite having substantially higher originations than some of the men in the firm. In each claim, law firms made a juicy target because no formal process existed for partner promotions. Women were often non-represented or very lowly represented on the executive committees which determine these promotions, and that the promotion disparities could be explained by gendered criteria and judgments, since they were often not objective. All three of those cases filed in 2016. Oracle America, this is a very recent action by the DOL alleging that a technology company systematically paid its white male employees more than other workers and unlawfully favored Asian applicants. The department in its complaint said that white male employees with the same job titles, even when taking into account experience and seniority, were paid more, and that Oracle is far more likely to hire Asian applicants for product development and technical roles. And, of course, the department also said that the investigation, which began in 2014, Oracle refused to provide relevant information about its pay practices. And then the Coates case, I think we were hoping for a decision in it just to see how the new California state law would be applied, but there was a settlement instead. These were attorneys alleging that they were unlawfully paid below their male counterparts. I think the settlement is helpful because it'll show that some concepts that may, on a go-forward basis, be helpful to note could be in play. An internal compliance officer to monitor compliance, annual statistical analysis, and benchmarks over a 3-year period to increase women in higher salary grades.
Okay, and recognizing that we have only a few minutes left, I want to dive into and highlight some of these steps for employers to consider. Won't go through all of them given our time limits, but do want to highlight some of the things that I think are probably most important. And I think the first bullet point is one of the most important points. And every organization needs to have someone who is familiar with these federal and state and potentially local laws on pay equity and is responsible for monitoring a company's pay practices. Oftentimes, the individuals that are involved in compensation decisions may be looking at compensation decisions for a particular department or for a particular group, and there's really no coordination among different individuals charged with that responsibility in terms of how they're evaluating and setting compensation. And as we discussed earlier, sometimes jobs that are similar in the work that is being performed may be compared against each other for purposes of a pay equity analysis. And again, with separate individuals performing or making those decisions, there may not be that necessary coordination. So there has to be someone who's really charged with that responsibility. Secondly, job descriptions are so important. Sometimes I don't think they give the focus and the attention that they really deserve, and that's especially true in the pay equity sector, because so often those job descriptions can be a valuable tool to explain why there are differences in pay among certain jobs. So certainly, requirements that are listed in terms of certain types of experiences, certain types of educational levels that need to be attained, that can go a long way, again, to establishing some of those defenses that we talked about earlier, that there are certain educational levels that have been identified and have been explained and communicated to employees. Analyzing personnel decisions that influence compensation. Compensation of any individual employee is something that is made really over the life cycle of that individual's employment. And there are many personnel actions that play into ultimate compensation. It may be promotions, it may be merit increases. Those different stages or those different decisions that impact compensation should really be kind of isolated and looked at to make sure that they're all being handled in a way which is not subject to a claim of bias. Along those lines, compensable factors should be looked at and again identified. So we can say, here are the factors that we have this discernible criteria that we use, here's what they are, and here's how we've communicated them to employees. So it is a certain level of experience, it's certain types of training. And when doing that type of analysis, if you group jobs into pays or bands, using your defined compensable factors, you will get a sense if you have any form of disparity. Obviously, when you're doing these types of analysis, one of the things you may want to consider is whether you do them under the cloak of attorney-client privilege, because by engaging in these analyses, those types of analyses are potentially subject to being discovered in any form of litigation or enforcement action, and you want to consider whether those need to be privileged. We're running out of time, so let me just highlight a few more. We want to look at all forms of compensation. We don't want to take our eye off the fact that it's not just salary among individuals that would be looked at. It's all forms of compensation. So it's benefits, it's bonuses. Separation pay could be a subject to a claim of unequal pay. So they're all of these areas are important to look at. Clearly, keeping records of the reasons for pay adjustments is very key, and that will often come in the form of resumes, offer letters, the job descriptions that we've talked about. Training, I think, is just so important and often missed by companies. We do training in the anti-harassment area, in the anti-discrimination area, but I think training on these pay equity laws is not something that I think we do enough of. And I think that all of our managers and supervisors who play a role in this process, even if it's just evaluating and not ultimately setting compensation, would be well served to be trained on these various different laws. Again, running out of time, I think we're 2 minutes over. We've left you with some more of these steps to consider. I think that in light of all of the changes in the law, considering whether to conduct a pay equity study should be something that the companies are giving a lot of thought to sooner rather than later, because I do think that it will, Evan mentioned some of the ways those can be used under some of the new state laws. It also is just a really effective tool to identify on the front end whether any additional steps need to be taken. So we thank you all for your time. I want to quickly say that for those of you in New York who are seeking CLE credit, we do have the CLE code that you will need to use on the evaluation form, and that code is DOG24. So again, it's DOG24. Thank you so much for your participation today. On behalf of myself and Evan and Steve, we appreciate your time.
That does conclude today's conference. Thank you for your participation.